This room will have Stephen Teppler talking about, can trusted computing generate trusted evidence?
Good afternoon. You may be wondering why a lawyer is here. I was wondering myself. I guess I should give a little information about provenance here. I'm the current chair of the ABAZ Discovery and Digital Evidence Committee, but we kind of grew out of the Information Security Committee, and started crowding out talk about security because e-discovery basically pretty much is a corollary function to information security. Find me the information security principle, I'll find you this corresponding e-discovery principle, and why and how the e-discovery principle kind of grew out of the information security principle. Authentication, kind of interesting, but identification, collection, preservation, that sort of stuff, custodian issues, all the stuff that you deal with, access issues, all come out of the information security arena, but have kind of percolated into the electronic discovery arena. So the problem is that I got into this kind of ass backwards because I got into the evidentiary quality aspect of digital evidence when everybody was still in the how do we get this stuff. And we're still in the how do we get this stuff arena. How do we find custodians? How do we find repositories, not suppositories? We don't want to make them into suppositories. Although I know defendants who've done that. You want to find out who your custodians are. You want to find out what kind of format your ESI is stored. You want to find out what kind of production issues there might be, what kind of search issues there might be. But let's start by going 30 years ago. A long time ago, there was a Second Circuit Court of Appeals in New York. A judge named von Grafflin basically called into question the reliability of computer information in a dissent. It was a patent. Case called PermaPaint. And basically, he said underlying data may be hearsay. Errors may be introduced in any one of several stages of processing. The computer might be erroneously programmed to permit an error to go undetected, or programmed to introduce error into the data. This is very well done, considering this is a judge from 1977. And the computer may inaccurately display data or display it in a biased manner. Every one of these is a challenge point which has gone totally ignored, for the most part, for the last 40 years. With the onset of electronic discovery, this is slowly changing. I teach at a law school down in Naples when I'm not working, and this is one of the issues that I try to drill into my students' heads, and it's easier than it has been. Anyway, so Perma Research was the name of the case. 30 years later, the world recognizes the most information is electronically generated and stored. And it's sourced. Legal proceedings are inundated with computer-generated information. In the field, we call this electronically stored information. We also call it ESI. Call it what you want. It's electronically generated and somehow stored or recorded on some sort of medium. December 2006, the amendments to the Federal Rules of Civil Procedure, which is the context-setting instrument for federal courts across the nation. How do we start a lawsuit? How do we file motions to get certain types of relief from a court pretrial? How do we discover information? How do we block the discovery of information? How do we assert certain privileges against which would help you block the discovery of certain information, et cetera, et cetera? That's all the Federal Rules of Civil Procedure. But in 2006, they were expressly altered. They expressly amended to permit the discovery of electronically stored information. Only 40 years, 50 years, 60 years after the first binaries were produced. Lawyers are very forward-looking. So the evidentiary challenge is that this is your evidence, okay? By the time you see it or jury sees it, it has been rendered at least 3 times. You think the operating system gets to it, the application gets to it, the operator gets to it, the user gets to it, and then the graphics generator gets to it. So by the time you see it on a screen, you're seeing what we call a view of a view of a view of a view, unless you have a reliable chain of generational custody and representational custody. What you perceive may not be in what order these zeros and ones were first generated. And that's really causing a problem for lawyers because they figure if it comes out of a computer, it's got to be correct, right? And if it comes out of a computer all the time the same way, and it always works the same way because I'm the person who turns it on and spits out the same stuff all the time, it's got to be true, right? It's got to be reliable, got to be trusted. This is one of the problems we're experiencing. So, what is evidence? It's all about the evidence. It's not about getting it. It's really about the evidence. It proves facts or proves a contrary assertion to a factual assertion made of you that a trier of fact, either a judge or a jury, will then find to be admissible. So electronically stored information is evidence. So, admissibility requirements. You just don't say, here, Your Honor, admit this into evidence. Evidence is considered admissible. There's always these, there are preconditions and predicates to admissibility. To enter into the realm of being admissible, you have to satisfy certain predicate elements. One of which, and there are a few, is authentication, not authentication. Okay? This is authentication legal style. And this has caused a huge amount of problem back in the old days when we had the NR bit, the non-repudiation bit. And I was one of those people to scream about how some marketroid had changed the function of the NR bit to indicate an expression of intent to be bound, right? And Turing machines are still not around, and so I didn't see how the function of a bit would tell me that I intended to sign something. Especially since if somebody held a gun to my head, I could prove that I didn't have intent to sign it. Or if somebody had a catastrophic compromise of CA, perhaps. Maybe that would indicate that that was not an intent to sign. So there were all these defenses against which the NR bit had no clue. And so I think the NR bit has now been deprecated to a something else bit. I'm not sure. I have to remember what it was. I have to ask my friend Hoyt Kesterson. But in any event, so authentication basically says who, what, where, when, and you have to demonstrate to a court this is who created it, when it was created, what was created, where it was created in some instances, and sufficient enough to find that the evidence is what it purports to be. What does that mean? That means that I have to basically have a very, very small, what's called a very low threshold, prima facie threshold, to get it authenticated. If a jury could believe it, then it can get admitted. It doesn't necessarily become admitted, but it could be. And the threshold is very low. Hearsay, it has to not be hearsay. What is hearsay? Hearsay is a statement made out of court, right, by an unavailable declarant, somebody who speaks out of court, offered to prove the matter of the truth asserted. He said he murdered her, okay? Unless you get, Tom said he murdered Mary, okay? So you would have to get, this statement is hearsay. Why? Because Tom isn't here to testify whether or not he really said it. And the truth of the content, the truth of the matter asserted is whether he murdered Mary. Now, think contextually and say, well, that's one thing, but in terms of how you look at hearsay, what if you just wanted to prove that a statement was made? That's not hearsay. We had a conversation, not the content of the conversation. Why is that important? Because metadata, which is context information, is also the type of information that would not be hearsay in an otherwise hearsay statement like a memorandum or email or a text. And metadata can be more as well. So a flowchart might be helpful. This is how you get information admitted. It's easy, right? So you go do the flowchart, and this caused no end of grief to my lawyer friends. Right? But it works. I mean, this is how you do it. Lawyers really do work in a kind of a logic tree manner. Except our logic tree is a lot longer than yours, and sometimes that last statement, therefore, then, whatever it is, doesn't happen until after the conclusion of the case, which is why we say we're backwards looking. Okay? So is it relevant? Okay, I'll give you a whole course in 10 minutes. Is the ESI relevant? Which means, does it have some connection with the claim or defense in a case? If it's not relevant, it's not admissible, okay? Is it authenticated? We just spoke about that. How do you authenticate it? With electronic information, you have to show that information was created, by a person at a certain time. He has to testify, she has to testify to it. Perhaps have some experts show how the information was generated, how it's reliably generated. Doesn't mean that it generates reliable information. It just means that it's been reliably generated. There's a difference, okay? And what's interesting about that is that there's an interesting authentication mechanism which has to do with showing how certain characteristics of information lend to a belief, lend credence to the authentication of the information itself. So think hash values, think anything that might show unique attributes of information that would help establish its provenance as evidence. So hearsay. It's hearsay. Does it fall under an exception? We'll talk about that in a minute. Here it is. The hearsay exception, the business record exception. So an email is, if you're going to try to admit somebody's email that's not yours or your adversary's, then there's no way for you to authenticate that email because the person who created that email, their speech, that's an out-of-court declaration, that person's not available. So there's a business records exception. It comes from the shopbook exception. It's something that had if you had entries into a ledger and you kept entering entries into the ledger the same way, the same time, it was considered reliable because the idea was that you wouldn't create fraud in a systemic fashion routinely over a long period of time because you wouldn't be able to operate that way. So that was considered in the paper arena to be okay for admissibility. So business record exception, was it made at or near the time the assertion of its relevance, okay? So it's not when it was stored or when it was this, it's when the relevancy of the information is asserted is the time that you have to demonstrate. Does the source, the computer or person, indicate a lack of trustworthiness? Oh, trust does enter into the equation for evidence, okay? But the question is, it's kind of a condition subsequent, but if you can show lack of trustworthiness to the source, you have a way of getting that information not falling under the hearsay exception, which would permit admissibility. So does the method of preparation indicate a lack of trustworthiness? All of these issues will come into play with respect to evidentiary admissibility for electronically stored information. Very few lawyers are doing this at this point. I am, a handful of others are. This is pretty much the future at this point. So, in any event, there are also Florida rules of evidence, which are corollary, which basically are almost the same as the federal rules. Even if it's not a business record, does it have equivalent circumstantial guarantees of trustworthiness? That's what we call a residual hearsay exception. Now remember, these are memos, these are text, tweets, pictures can be hearsay, not to show that a picture was taken, but to show somebody running a red light. Okay? That's different. That's hearsay because that is a statement. Is a statement offered as evidence of a material fact? It has to be a material fact or it doesn't make much of a difference. There's probative value, which you don't have to worry about unless you're a law student taking the bar exam. And is it an original writing? What is an original writing? There's no real, there hasn't been an upgrade to the federal rules of evidence to reflect the onslaught of electronic information, other than to pay lip service to the fact that ESI exists. So that's what we go through. So remember when I said the threshold for admissibility is really low? Party seeking exhibit need only make a prima facie showing that he or she is what it claims to be. Show me some reason, something other than a suspicion that it exists. Call somebody up and say that they were at the computer, and that's how that computer information was generated. It does it the same way all the time, and here's an example of it, and here I am to swear about it. I've been doing it for 10 years. Thank you very much. Please admit it, right? And that's it. Have you offered a foundation from which a jury could reasonably find? The problem with this is that information is so easily forged and so easily manipulated that you can have competing sets of evidence, both of which will go to a jury when one of which is obviously false or forged. Okay? That's the big problem we have with trusted evidence, with trustworthy evidence. And stop me and ask questions. This is... it's a threshold preliminary. It's subject to later review by cross-examination. That's all well and good, but if it goes to a jury, you stand a 50% chance of losing your case if you have falsified evidence introduced against you. And it's happened. It's happened on more than one occasion. I've seen it happen. So the degree of foundation required depends on the quality and completeness of the data input, the complexity of the computer processing, the routineness of the computer operation, the ability to test and verify the results of the computer processing. Well, it comes out all the time the same way. And we've tested it. We've done it 50 different times. And 50 different times it came out with that value. Therefore, it must be right. Right? Wrong. So, does this ensure that that trusted ESI is admitted into evidence? Of course not. Doesn't. ESI is evidence, but it's composed of binaries. Binaries, they don't know from nothing, right? They're just zeros and ones. We don't know whether we're evil or good, or we're bad, or we're telling the truth, or we're not telling the truth. So, what way can we ascribe, how do we associate any kind of indicia of trustworthiness to digital evidence as it's being generated? We're trying with identity, but identity doesn't mean that your content is what it is truly what it is, especially if you control over the environmental variables which create the information. They just exist. Binaries do. So this is the non-repudiation bit. I think I could almost remember what it was called. What did the NR bit, Bob, get deprecated to? But it ain't the non-repudiation bit anymore. But anyway, I was a little bit ahead of myself. You couldn't, the intent issue is something you can't technologize, at least not yet. Federal Rule of Evidence provide that authentication is a precondition to admissibility. Again, over and over again, it has to be what it purports to be. Circumstantial evidence, testimony, you haul in the computer, turn it on, and watch it spit out crap on a screen. Yeah, that's good enough usually. Provenance. Okay, really what we're concerned with is the provenance of information. Like an antique. How do you know that an antique existed at the time that you're asserting its creation? You look at magazines, you look at circumstantial information, perhaps something that's been held in a family for 100 or 200 years, maybe a receipt, maybe some sort of picture of somebody standing with a parasol, under the Eiffel Tower with a Van Gogh, who knows, all right? But the idea is that you have to establish provenance for electronically stored information. Digital data is inherently malleable, it's mutable, that's the nature of the information, that's the nature of the animal. It exposes the inherent frailty of digital data sought to be introduced as evidence. Why should it matter that ESI needs only a prima facie showing? You consider the source of the origination of the evidence, and again, we're back to these. You can't talk about these in court, because the judge is going to look at you and say, don't talk to me about binaries, talk to me about the evidence. And then you're going to be kind of in a circle of hell. So what you perceive is binary data processed at least 3 times, operating system application and graphics, computer-generated information, really, again, a view of the view. How do we know the binaries would support even a prima facie finding? We don't. Because we're permitted to rely on corroborating evidence, liars, cheats, and thieves, and some honest people along the way. And computers that don't know they're lying because binaries have no clue. Right? And computer programs have no clue. There isn't, computer programs are like, I'm evil, I'm going to spit out erroneous information. No, I'm doing exactly what I'm programmed to do. Thank you very much. Computer-generated evidence, vast majority of today's environments is not testably reliable. That's the term that we've started to use. Show me how information is testably reliable, and I'll show you evidence which has a greater provenance and should be a foundational standard for admissibility. So why is it important? Okay, so let's play with pixels. Okay, look at let's see, let me go back and forth here. All right, take a look at the first row. And first row, there's a very little difference on the left side with that bright line that somehow manages to go from the left side of the heart, of that portion of the heart, to the right side. Well, that shows, if you go to certain cardiologists, that shows an infarction that's about to occur, a heart attack, a blocked artery, right? The problem is that this is a resolution issue. Now, this is an innocent change, but I got to tell you that this innocent change, I'm getting ahead of myself, that innocent change can make a real difference when you're submitting insurance information. And right now, there are no controls over electronic health record generation. Anybody who's selling them here, I'll step away so you can throw tomatoes later, but they're just an invitation to defrauding the government. But in any event, so that's one part. Here's another thing, another picture that I think is kind of a little more interesting. Take a look at the second and the fourth slides and see that white line on the ribs about 1 from the bottom on your right. That's a cancer of the rib. That's a cancerous lesion on the rib. But cured. How? $50 in Adobe Photoshop. All right? Let's go back. Let's do this again. I love this, right? So you have two options here. And the options are this. And this is the doctor, the radiologist, they're in control. They can make this happen. Okay, so you can say, I want to say that this person had cancer and I want to collect for all sorts of procedures that I probably may or may not do. Or even worse, what I'm going to do is I'm going to say that there was never any cancer when I took that radiograph. It must have just happened yesterday. And guess what? Both of these images are going to be admissible. Why? Because somebody's going to swear that that's what came out of the radiograph machine. So I paid $50 for that. Anyway, so authentication. In relying upon data processing, there should be no more necessity for oral testimony concerning the reliability than that of the manual procedure supplanted, whether bookkeeping, order preparation, or mathematical computation. That's from 1999. But both Florida and the federal rules require originals were available. What's an original, right? Original, there can be 50,000 copies of an original, each of which arguably is an original for legal purposes. To me, it's instantiation. What was the first instantiated version of that data block? That's all I care about. Okay, and it all kind of implies time, and I have a slight bias towards time issues, but we can talk about that after. But in any event, so instantiation and origination is really what I prefer to use, and what more and more people prefer to use. And actually what a lot of people who come out of the security arena and into the electronic discovery arena are beginning to say. So, characteristics of the source of data, environment, including controls and provenance of the initial creation of digital data. I kind of use data and information interchangeably, so you have to excuse me. First instantiated ESI for either an image or document viewed on the screen, generated paper printouts or the binaries, and the ordered sets of zeros and ones that comprise the true source data used to produce the screen image or paper printout. That's kind of what I discuss when I'm looking for those sorts of images from the other side. I don't want a copy of something. I want the first instantiated version, to the extent they can provide the first instantiated version. But the data information actually perceived by a human reader may be the last view, and especially with electronic health records, what is generated by these programs is not what you see when you request your records from your provider. They're two totally different things. Whether or not you have all the metadata fields, whether or not all the instruction sets are there or comments are there, you will not know. And we know this because we just came out of a large case against a large hospital entity in which this was painfully apparent. Hash functions, they're really useful in electronic discovery. You can use them for deduping, you can use them for actually finding stuff as well as deduping. Some people have used them to prove that information is what it purports to be, but that's only as of the time that you create the hash, and only if you trust the environment in which the time was, time wasn't associated with the hash, but the time in which the operator asserts that he applied the hash function to the data block. Okay, been a long time, It's been around a long time for you guys, obviously. Cryptographic hash functions, obviously one-way transformations, don't have to discuss that. This part I tell people who don't do this stuff, right? But in 2008, there was a Chinese university professor who theorized a SHA-1 forced collision, which is really interesting. Not so much for the fact that, that she theorized the forced collision, but the legal effects this forced collision had. And let me go back. And what she said was that if you had enough big iron and you input this, two data blobs at the same time by the same operator into the function, you could force a collision with a SHA-1 hash, right? Except for one thing. And so there was this big foo-foo about whether or not this meant that you'd have, forged information all around. Well, we looked at it during the RSA conference. My colleague and I talked about it and said, well, two things. Number one, if the same person has to be the person who inputs both data blobs, it means that who is ever offering the false information, the true information, is also offering the false information by implication. The second thing is that the data blobs that were input to force the collision were two disparate data blobs. What is the likelihood of two near identical data blobs being put into the same function at the same time by the same operator. I'm thinking monkeys and typewriters and Shakespeare. So really the whole idea of the threat to provenance from that perspective kind of fell apart. But that was fun. So you can dedupe, you can check content integrity with a protected hash. Digital signatures cryptographically protect hash values. This is explanation to the uninitiated. E-discovery vendors and forensics tools claim to protect the data acquired process by using hash values. Well, it's fine, except that you have to trust the forensic acquisition and the operator who basically created it. If you change the, there's nothing that stops the data set from being changed and the forensic acquirer from backdating his system to show that the evidence was created the forensic image was created at that time. It also says nothing about the information contained within the forensic image. So neither e-discovery vendors nor forensics tools protect the hashes they generate. Duh. You'd think that would be the case. No, it does not. Some of them are still using MD5 hashes. So it may indicate that information remains unchanged by anyone other than the person generating the hash. Lots of reliability here. Court found some courts are finding requirements for heightened trustworthiness. Defendant had not provided any specificity here about record-keeping practices, and so the court characterized email communications as more casual and appears to ascribe a higher degree of trustworthiness to the business records exception. I think this is a trend which is going to continue. I think in your business, if it's something that you should be looking at, generating trusted content should mean generating trusted evidence or trustworthy evidence. It would be easier to get admitted and easier to exclude non-trusted content. The idea is if you at least move yourself to a higher degree of trustworthiness with the generation of information, it means that whatever has not moved to that second level, you can arguably say, don't even consider that, Your Honor. And that's maybe where we want to go here. So email is typical of more casual form of communications, usually kept in the ordinary course of business. The court here required a higher degree of reliability. And let's see. Here's another case in which emails did not fall under the business records exception because defendants failed to establish the sending and receiving of emails. You have to show that it was sent and received. Otherwise, is it an email? It's a something else. You can't really say it is. And they applied the Deepwater Horizon test. Deepwater aptly describes the test for reliability. First, email must have been sent and received at or near the time. I'm going to go through this real fast. We're speed dating. Second, email must have been sent by someone with knowledge of the events documented in the email. Third, email must have been sent and received in the course of regular business activity, which requires case-by-case analysis of whether the producing defendant had a policy or imposed a business duty on its employee to report or record the information. Fourth, it must be the producing defendant's regular practice to send and receive email that record the type of events documented in that email. How many conditions are in that sentence, for crying out loud? This would require proof of a policy of the producing defendant to use email to make certain types of reports, et cetera, et cetera. Fifth, the custodian or qualified witness must attest that these conditions have been fulfilled, which certainly requires an email-by-email inquiry. This is the BP case. This is the Deepwater Horizon spill case. Last, the objecting defendant is permitted under the rule to argue that the particular email should be excluded due to concerns of lack of trustworthiness. Gee, this keeps on coming up, doesn't it? How many times, talk to your lawyers. Ask them about this. They will cross their eyes because they have no clue. Okay? And they're good lawyers probably, but they still have no clue about this stuff, and it's coming behind them like a freight train. So there's more. All right, it's necessary to prove, however, that the authenticating witness provides factual specificity about the process by which the electronically stored information is created, acquired, maintained, and preserved. Oh, gee. You know what? The idea is, why are we looking at ESI and protecting it months after it's been generated when we can take care of that business up front with a minor process addition and kind of imbue it with testable reliability, testable provenance? Okay, and that's the whole idea behind trustable evidence. Bottom line, the increasing complexity of computer technology requires a more precise focus because electronic documents are easier to alter after creation. That's it. That's the bottom line. So, that's it. I'll take questions. We have time for that. I didn't put you to sleep. Mostly. this has become a really big issue. Evidentiary quality is something that lawyers are typically not paying attention to because both sides are basically oblivious to it, and courts are not going to bother themselves with it except for a very few enlightened jurists, because there's just no way for them to, nobody has mounted the challenge, nobody knows how to mount the challenge. How many, yeah?
Just curious, in the technology committee you described, do you get down to the level of recommending specific technologies, or not at that level? Just functionality?
We haven't gotten down to recommending technologies. Yes, we recommend technologies where we like technology with vendor agnostic. So, we like digital signatures. Yeah, we like time stamping. We like all, the stuff that should be done early on in the data generating process, because once you do that, all the rest of the stuff that you have to do through the information lifecycle that normally you would have to, devote resources to and/or people and money and time, and it's basically non-profitable type of activity, can be dispensed with. But you'd be taking away a lot of. There are a lot of invested organizations and entities that make a lot of money off that life cycle processing and post-creation processing that kind of imbue quote-unquote integrity or show that something hasn't been changed since it's been created. Well, if you could show using, if you could imbue your information immediately with some sort of testable reliability, it almost doesn't matter where else it goes in the wild, because wherever it goes, it can still be tested. And so, yeah, we recommend technologies, but for the most part, it hasn't. It's fallen on deaf ears for now. I'm not saying that it's going to fall on deaf ears forever. There are judges such as Judge Grimm, who I spoke about here. There's a judge named Faciola. There's a judge named Peck out of New York, D.C., and Maryland. They're all beginning to pay attention to this. There's a nonprofit consortium called the Sedona Conference, which has been paying attention to the more the acquisition of information, but now is starting to turn its head and look at the evidentiary quality of information that's acquired. So, we may be at a turning point, but, I started talking about this about 1997, 98, and I was advised very strongly to keep the Kool-Aid level low in my drinks. And it's true. I mean, it was very, very, it was painful, because I knew it was coming down the pike, but there's only so much shouting you can do when everybody's still worrying about how to get the information rather than what to do with it once you've gotten it.
Another question. So you think of, just to have us technology guys would have something to talk about too, is a case recently where what we would call trusted computing technologies, trusted computing technologies, played some sort of instrumental role in preserving or presenting or authenticating evidence?
It hasn't, and I think it's because either it hasn't been deployed in the enterprise to do that, or your lawyers haven't been, or the lawyers involved, and this is where IS really comes into play. It's not IT, it's information security. Because information security is concerned with the integrity of information, so why not the integrity of information, which may possibly wind up as evidence in court? So I think it's a matter of educating your lawyers and kind of repurposing part of what IS does to encompass discovery activities which are not so much pending as impending. In the federal system, there is a requirement that if you have a reasonable anticipation of litigation, you are supposed to preserve information. How that information is supposed to be preserved, in what format must it be maintained as it's being preserved, these are all corollary questions, but if you have to preserve this information, how do you go about preserving it? And do you always have to be, even if it's a reasonable anticipation, do you always have to act on an after-the-fact, cows left the barn basis, rather than by using or deploying a process very early on, which automatically will take that into account, whether or not information will or will not be potentially evidence in a future case. You've got the provenance, testable provenance, already imbued into the data. so that when you get that inevitable litigation hold letter, which is that letter that says you must preserve everything because this person has fallen under a ladder, and I want the videotapes, I want all the time cards, I want all the memoranda, all the emails, all the text, I want the 15 Instagram pictures that were taken, or the Vine pictures that people had and were able to capture. These are the sorts of things that if you look at your document retention policy, your data generating policy, you should be able to view first. And the technology exists in the chip. The standard certainly provides for enough of that to be able to do that. The question is for some enterprise to be able to actually apply that in a way that's meaningful to the enterprise, because discovery costs in litigation are very high. And if you start down the road of asserting forgery or alteration, you're going to open up a hearing and an evidentiary hearing and additional discovery and cost and intrusiveness on your enterprise, which includes your lawyers and your IS people and the people who are in charge of litigation holds, and maybe an investigation by an independent forensic examiner to make sure that you've looked at all the data repositories of the custodians, to make sure that you've covered everything. Maybe you could have prevented that by deploying this earlier on. It's a long-winded answer, but I certainly think there's opportunity out there. It just has to be spoken about in the right way for enterprise to understand. Gartner has said the e-discovery services market, this is not the legal portion of e-discovery, somewhere around $4 billion by 2017. That's big numbers. That's really big numbers, and I think it's understated.
That's not even paying the lawyers.
Pardon me? That's before you pay the lawyers. Yeah, you think lawyers making all the money on this? Nay, 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 nay. No. At one point back in 2007, it was like $3,000 a gig for processing fees. It's down about $100 and give me a bid. And so, but vendors are finding a different way to charge, and it's either machine time or people time. And it becomes very, very fuzzy as soon as you get these like pyramidal vendors who basically take over lots of different aspects of e-discovery, and each one of them has their own markup, and then you get the final picture and an estimate. And it can be hugely expensive, especially in class actions, mass torts, that sort of stuff. You'd be surprised at how bad it can get. Yeah, I'm sorry.
So a question on the correlation between this and aspects of privacy, which has many similar characteristics, although confidentiality plays a greater role than integrity, although a lot of the technical components to do both are similar. And perhaps the third piece, which is publishing. The evidence that Disney produced this movie that was DRM'd inside a Disney factory based on a hardware security module owned by Disney with keys that they take very great care over, and then I discovered that this content came at this place that was consumed. The ability to prove that that was actually originated as Disney's content is probably substantially better than I downloaded a file.
So I'll play the law professor here. Why do you say that? This is called Socratic dialogue.
I think because I can assert the process that applied the markings to the data, and so therefore that once that process was complete, because those markings have in and of themselves third-party attestation, then I should be able to prove that they were added to the content at that time. So the content's integrity from that moment of marking forward.
Where does the moment of assertion come from? The assertion moment come from?
So if I assume that the assertion had a physical component to it, a TPM or a hardware module of some kind, then I would have to tie it back to that specific device, and then the secondary question becomes proof that the device was where it says it was.
Right.
At least I'm back to some aspect of physicality.
No, you are. And part of it is that, to a judge, to a court, the system that Disney has will provide a lot more credibility than an outsider saying, but I created this script, for instance, 2 years earlier. That may or may, that may be true. And on its face, it looks, the argument is a good argument. The problem is that if Disney controls all the environmental variables, and the movie was worth, the script was worth $1 billion, and they think that by backdating or doing something, by recreating history, that they can ensure that, they'll still get that credibility, unless you'll be able to show from your, from your outsider's perspective that there's something wrong. And the problem with that is that the mere skepticism won't get you to the point where you'll be able to say, bring in the hordes of forensic investigators. I want to see, I want to see whether or not there's really gappiness or whether there's some sort of odd arrangement of files that would tell me that things were really kind of screwed around with during that time. So I'm not saying that Disney would do it, but when there's a lot of money at stake, I think that the risks involved are heightened. So, and in essence, I think that, going back to, you don't have to go back very far. Go back to Enron and Anderson, and you can see that it does happen. And, what you don't want to have happen is something catastrophic. And that's where, you start beginning to wonder. One of the things that we've been talking about lately is computer code in cars. I think now each Japanese and American car have either 40 or 80 gig hard drives in them, filled with data. It's all encrypted except to the car, which means somewhere in that car's firmware is a key in clear text. Okay, but we don't worry about that. Right. So you have all this information in the car, and you have these modules, which may be modules built on modules, and if you have buggy code, and buggy code causes an unintended acceleration or braking failure or fire or whatever, you may have incredibly huge liability. How are you going to prove who created what code at what time? Right? The issue becomes extremely nuanced and could be extremely costly for the enterprise unless it takes some sort of care, because one module may have innocent good code in it, and the module upon which it has a dependency may be faulty. And to get to that code, first of all, you'd have to get the code. You'd have to be able to compile the code. Of course, I'm saying it'd have to be uncompiled code to be able to read it and analyze it. And all these things are data-centric, and they're evidence that has to have some sort of provenance, and it's going to be a nightmare trying to get this stuff authenticated in the future. I went on probably past the response to your question, but
no, it was excellent. So the certification is the opportunity to add a theoretical third-party independent.
Yes.
On my process.
Yeah.
So,
to the extent that the idea is you'll never get perfect third-party, absolutely saintly, uncompromisable. But the further out you go, the more foundation, the stronger that foundation will be. That third-party attestation says, I have no dog in this fight. I don't care. Okay, that's the whole point of it all. It's an attestation that something happened and the content is what it purports to be. What you interpret it to be is a different story. But that set of zeros and ones, that remains inviolate, and you can't argue that. And I think that'll make all the difference in upcoming litigation.
So huge value would be separation of processes more than one supply. So if I had encrypted content at Dropbox, but encrypted content at Dropbox, they own the keys to the encryption and the content, versus I have the content at Dropbox and the keys and encryption done by something else, I'm in a much better situation.
Absolutely. As recent events have shown, yes.
Right. Exactly.
Lawyers have a confidentiality requirement, and a lot of my colleagues and law students use Dropbox, and I say, fine, you just violated your duties of confidentiality. Why? Because Dropbox has an escrow of your key. And guess what? Upon quote-unquote legal inquiry, they'll release the key. They'll use the key. Thank you very much. And when lawyers hear it, they'd say, well, that's not true. They encrypt. And I'll just look at them and say, fine, thank you, goodbye. If you just didn't hear what I said, I'm not going to repeat myself, because I'm tired of knocking my head against the wall and telling people that, encryption is if your secret is shared by someone over whom you have no custody or control, it ain't a secret anymore.
So in thesis, any organization that's currently using Dropbox that put content up that's under NDA is in violation of their non-disclosure.
Potentially in violation of their non-disclosure agreement. Yeah.
Awesome.
And I think with that, I'm done. Thank you very much.